Hi, Josh.
Hi, Amanda. What are we talking about today?
We've been talking a bit about the intersection between our Connecticut workers' compensation laws and then various state and federal disability laws that protect employees at work, of course, here in Connecticut and across the country. We have another video that we did a little while back, which answers this question and deals with these issues on a much broader basis. But I wanted to focus in on something much more specific today, which is say you've suffered from a work injury. That work injury is accepted, meaning it's compensable, but you're not quite ready to get back to work. And maybe you need light duty. And light duty could mean a lot of different things. Maybe it's a standing restriction, maybe it's a lifting restriction, maybe it's a time restriction, meaning you can only work X number of hours per week. Are you entitled to that under either our Connecticut workers' compensation statutes or any of our state or federal laws that protect disabled employees at work?
The answer is yes, Amanda, but I want to explain the thought process on this. As you know, there is an overlapping system of federal and state laws in this country, and both of them protect workers. There are federal laws that protect workers and state laws. So, the federal system has a law called the Americans with Disabilities Act that requires employers to provide a reasonable accommodation for disabilities. And many, but not all, workers' compensation injuries will qualify as disabilities. Pretty much everything that's going to knock anybody out of work for any significant period of time would qualify as a disability. Under the Americans with Disabilities Act, and likely under our state counterpart, employers only have to provide a reasonable accommodation if it allows the employee to do the essential functions of their job. In other words, it is not a reasonable accommodation to say, I want a different job, I want different job duties. That is not going to be a viable claim or a viable option under our disability law. So then it becomes a question of, what state do you live in and what state laws protect you? Here in Connecticut, and I should say the workers' compensation system is a state-specific system. Every state's got their own system. They all look similar, but not the same. Here in Connecticut, we have a statute 31-313, and that is a statute that provides essentially for light duty work under some circumstances for Connecticut employees if they are out on workers' compensation. So if you have not yet reached maximum medical improvement in the eyes of your doctor or the workers' compensation judge, your employer has an obligation to transfer you to full-time work suitable for your physical condition if such work is available. So that's really a question of, is light duty work available in your job? If it is, your employer has an obligation to transfer you to it, but they do not, under most circumstances, have an obligation to create a light duty job just for you. Now, keep in mind, if they've created light duty jobs for other people, people who say were not hurt at work or have not filed a workers' compensation claim or are not represented by a lawyer in the workers' compensation system, that might be workers' compensation retaliation, in which case you would have a claim under 31-290A. But to answer your question, do you have a right to light duty work if you have an accepted claim in the workers' compensation system? The answer most of the time is yes under 31-313.
Really helpful information. Thank you so much. And we hope that's helpful to Connecticut employees who have suffered from a work injury. Thanks so much for watching, and we'll talk to you soon.